The United States Supreme Court has now ruled that magazine capacity bans violate the Constitution, and that ruling instantly alters the legal structure of firearm regulation across the entire country, because it establishes that a commonly used firearm component cannot be prohibited unless the government can prove that a comparable restriction existed at the time the Second Amendment was adopted, which in practice it cannot, meaning the modern regulatory logic that has shaped gun policy for decades has just been placed outside constitutional boundaries by the highest court in the nation. This decision does not exist in isolation, and it does not float above the law as a political signal or a cultural statement, but instead locks into place as a binding interpretation of constitutional meaning that courts, legislatures, law enforcement agencies, and citizens are now required to follow, whether they support it or oppose it, because constitutional law is not optional and does not adjust itself to opinion cycles, which is why this moment represents not merely a policy shift, but a structural correction within American law. For years, magazine capacity limits were treated as a compromise position between gun ownership and gun restriction, a political midpoint that allowed lawmakers to claim public safety goals while avoiding outright prohibition, and this framing gave such laws a kind of moral immunity that discouraged serious constitutional scrutiny, allowing them to survive more on emotional logic than legal coherence, until the Supreme Court finally applied the same analytical rigor to them that it applied to other fundamental rights. The logic used by the court is simple, narrow, and devastating to the legal foundation of these bans because it does not rely on modern statistics, projected outcomes, or legislative intent, but instead asks one disciplined question: whether the regulated item is part of the protected right, and whether similar regulations existed when that right was codified. And when the answer to both questions is examined honestly, magazine bans collapse under their own weight. Magazines are not accessories in the way that scopes, grips, or cosmetic features might be, because they are required for a firearm to function as designed, and a right that protects the ownership and use of a firearm cannot logically allow the prohibition of the very component that makes the firearm operational, just as a right to free speech cannot allow the banning of ink or paper, or a right to vote cannot allow the banning of ballots. Once that principle is accepted, the second step becomes unavoidable, which is the historical test introduced in prior rulings that requires the government to justify modern restrictions by pointing to comparable historical analogs from the founding era. And here the record is empty because there were no limits on ammunition capacity, no restrictions on firearm efficiency, and no legal framework designed to limit the effectiveness of arms owned by civilians during the period in which the Constitution was written. In fact, the historical record shows the opposite, which is that civilians often owned weapons equal to or superior to those carried by standing armies, that private warships existed, that repeating firearms were known and unregulated, and that the legal culture of the time assumed that the citizenry retained the technological means to serve as both a defense force and a counterbalance to centralized power. This context matters because the Second Amendment was not written as a hobby protection or a sporting allowance or a cultural tradition, but as a structural element of constitutional design meant to preserve a particular balance between the state and the people, and modern discomfort with that design does not alter its meaning, any more than modern discomfort with free speech alters the First Amendment. What makes this ruling particularly powerful is not its rhetorical force, but its restraint, because the court did not issue sweeping declarations or political commentary, but simply applied the same method to the Second Amendment that it applies to every other enumerated right, and in doing so revealed that the foundation of magazine bans was never legal in the first place, only tolerated. This explains why the reaction to the ruling has been so polarized, because it removes a tool that lawmakers had grown accustomed to using, and it does so not through negotiation, but through constitutional boundary enforcement, which is inherently resistant to political override. State governments that built entire regulatory frameworks around magazine limits now face the reality that those frameworks are legally hollow, and that enforcement of those laws is no longer constitutionally defensible, meaning arrests made under those statutes are vulnerable to challenge, convictions become questionable, and ongoing prosecutions are likely to collapse. For law enforcement agencies, this creates an operational shift because policies that once authorized seizures, charges, and arrests must now be rewritten or abandoned. And officers who act under invalidated statutes risk violating constitutional rights, which carries its own legal consequences. For citizens, particularly those in states that enforced strict magazine limits, this ruling restores legal clarity to an area that had been artificially criminalized, meaning ordinary behavior that once carried severe penalties is now recognized as constitutionally protected, not because of legislative generosity, but because of legal correction. This distinction is important because rights restored by courts are more stable than privileges granted by legislatures, as they cannot be easily withdrawn by political shifts. And this is why the ruling is more significant than any single election outcome. The political response has already begun, and it is predictable, with some lawmakers calling for new forms of regulation framed differently, some advocating for federal intervention, and others urging defiance through alternative enforcement mechanisms. But all of these responses operate under a new constraint that did not exist before, which is the constitutional boundary reaffirmed by the court. Future regulations will now be forced to pass a more demanding test, one that cannot be satisfied by moral arguments, public opinion, or crisis-driven urgency, but only by alignment with constitutional text and historical tradition, which significantly narrows the scope of permissible regulation. This does not mean that all gun regulation is dead, nor does it imply that the court has removed the ability of the government to address violence. But it does mean that regulation must operate within constitutional limits, just as it does for speech, religion, privacy, and due process. The deeper implication of this ruling is that it marks the maturation of the Second Amendment within constitutional jurisprudence, placing it on equal footing with other fundamental rights that have long enjoyed strict judicial protection. For much of the 20th century, the Second Amendment existed in a kind of legal shadow, acknowledged but not fully enforced, mentioned but not structurally integrated, and this allowed a patchwork of inconsistent and often contradictory rulings to emerge across jurisdictions. That era is now ending, replaced by a coherent framework that treats the Second Amendment not as a policy preference, but as a constitutional command. This shift is not inherently pro-gun or anti-gun, but pro-constitution. And that distinction matters because it reframes the debate from one of culture to one of law. It also reframes the responsibilities of citizens, because constitutional rights require civic literacy to be preserved, and ignorance of legal structure leaves rights vulnerable to erosion through incrementalism. This is why the ruling has long-term significance beyond firearms, because it reinforces the idea that rights are not subject to utilitarian calculation, and that courts exist precisely to resist the temptation to sacrifice principles for perceived outcomes. History is full of examples where rights were limited in the name of safety, efficiency, or morality, and those limitations were later recognized as grave mistakes, whether in the suppression of speech, the denial of due process, or the restriction of equal protection. The lesson of those eras is not that safety is unimportant, but that rights are the framework within which safety must be pursued, not obstacles to be removed. The Supreme Court's ruling on magazine bans fits within this broader historical pattern, acting as a reminder that constitutional design is meant to endure beyond moments of fear, outrage, or political convenience. As 2026 approaches, the legal landscape will continue to adjust, lawsuits will be filed, statutes will be challenged, and political actors will attempt to reinterpret the boundaries. But the underlying principle has now been clarified, and it is unlikely to be reversed without a fundamental shift in constitutional doctrine. This creates a period of legal consolidation where lower courts align their rulings, states adjust their laws, and citizens adapt their understanding of what is permitted, protected, and prohibited. It is not a dramatic moment in the cinematic sense, but a quiet one in the legal sense, and those are often the most consequential. Because once the law settles, it shapes behavior, expectations, and institutional norms for generations. The true impact of this ruling will not be measured in headlines or social media reactions, but in the slow, steady normalization of constitutional consistency, where rights are treated as stable and predictable rather than contingent and negotiable. This stability benefits not only those who exercise the right, but those who regulate around it, because clarity reduces conflict, litigation, and uncertainty. It also reduces the temptation for lawmakers to exploit ambiguity for political gain, because the boundaries are now more clearly drawn. In that sense, this ruling strengthens the rule of law itself, which is a public good independent of any particular policy outcome. Whether one supports or opposes widespread firearm ownership is ultimately a separate question from whether the Constitution means what it says, and the court has chosen to answer the latter rather than the former. That choice reflects an institutional humility that recognizes the court's role not as a problem solver, but as an interpreter, not as a designer of society, but as a guardian of structure. This distinction is often misunderstood in modern politics, where courts are expected to deliver outcomes rather than coherence. But coherence is precisely what allows democratic processes to function within stable boundaries. Without boundaries, politics becomes total, and every issue becomes existential. With boundaries, disagreement becomes manageable. The Second Amendment now sits firmly within that bounded space, no longer an anomaly, no longer a special case, but a right subject to the same rules of interpretation as all others. That normalization is perhaps the most important aspect of this ruling, because it signals that the constitutional framework is not fragmenting, but consolidating, not weakening, but clarifying. And that is why this moment matters. Not because it favors one group over another, but because it reaffirms the principle that rights are not granted by governments, but recognized by them. That principle is the foundation of constitutional democracy. And it has just been reinforced. Stay aware of how your state responds. Read the legal arguments. Follow the changes. Because constitutional shifts do not announce themselves with fanfare. They happen quietly. And then they shape everything that follows.